Every single day, you make dozens of contracts without even realizing it. Buying coffee, downloading an app, hiring a plumber, all contracts. But here is the wild part. Most people have no idea when those agreements are actually legally binding and when they are completely worthless. Today, we are going to change that. By the end of this video, you will understand exactly what makes a contract valid, what can make one fall apart, and how contract law protects you in everyday life. Whether you are a student, a business owner, or just someone who wants to stop getting burned by bad deals, this one is for you. Let's get into it. Section 1. What is a contract and why does it matter? Let's start with the basics. A contract is a legally enforceable agreement between two or more parties. That word enforceable is everything. Lots of people make promises every day. Your friend promises to help you move. Your coworker promises to cover your shift. But most of those promises are not contracts, and if they break them, you have no legal recourse. So what separates a regular promise from a binding contract? The law looks for a very specific set of ingredients, and if even one is missing, the whole thing can fall apart. Courts do not just look at what people said. They look at what the agreement actually contained and whether both sides genuinely committed to something real. This matters enormously in business. A company that relies on a handshake deal and skips the legal requirements could end up with zero protection if the other side walks away. Understanding contract law is not just for lawyers. It is for anyone who makes deals, which is literally everyone. Now that you know what a contract is supposed to be, here is the question that probably just popped into your head. What exactly are those ingredients a contract needs to be valid? Stay with us, because that is exactly what comes next. Section 2. The essential elements of a valid contract. For a contract to be legally valid, it needs 6 essential elements. Think of these as 6 boxes that all need to be checked. First, there is offer. One party has to propose something specific, not vague, not wishy-washy. I will sell you my car for $5,000 is an offer. Maybe we can work something out sometime is not. Second, there is acceptance. The other party has to agree to the exact terms of that offer. If you say I will buy it for $4,000, that is not acceptance. That is actually a counteroffer, which cancels the original offer entirely. Third, and this is a big one, there is consideration. Consideration means each side has to give something of value. Money, a service, giving up a legal right. All of these count. A promise to give someone a gift with nothing in return is not a contract, because only one side is giving something. Fourth, there has to be capacity. Both parties must be legally capable of entering a contract. Minors, people under the influence, or those with certain mental conditions may lack capacity, and contracts with them can be voided. Fifth, the agreement must be legal. You cannot enforce a contract for something illegal. A deal to sell stolen property is not going to hold up in court ever. Sixth, there must be genuine assent. Both parties have to actually and freely agree. No fraud, no duress, no manipulation. 6 elements. Miss one and the whole contract is in jeopardy. But what happens when someone claims they were tricked into signing? That leads us to something the law takes very seriously, and that is coming up next. Section 3. Genuine assent. When agreements go wrong. Imagine you signed a contract, but the other side lied to you to get your signature. Or they pressured you until you felt like you had no choice. Does that contract still count? The answer is, it depends. And the law has very specific categories for this. This representation is when one party makes a false statement of fact that convinces the other to sign. If a seller tells you a car has never been in an accident, but it has, and you only signed because of that claim, that could void the contract. Fraud goes a step further. It requires that the false statement was made intentionally and with the goal of deceiving you. Fraud can not only void the contract, it can open the door to additional damages. Then there is duress, being forced or threatened into signing. Physical threats are obvious, but economic duress counts too. If someone says sign this or I will destroy your business, and you had no real choice, courts may consider that contract invalid. There is also undue influence, which is more subtle. This typically comes up in relationships where one person has power over another, like a caregiver taking advantage of an elderly person to get them to sign over assets. The key takeaway here is that your signature alone does not automatically make something enforceable. The circumstances around how you were brought to that signature matter enormously. So what if both parties agree honestly and freely, but the contract just could not legally be performed? That brings us to an important concept: legality and public policy. Section 4. Capacity, legality, and what courts won't enforce. Not every agreement between two willing adults is something courts will back up, even if both parties are totally on board. If the contract violates the law or goes against public policy, a court will refuse to enforce it. We touched on legality before, but let's go deeper. Contracts for illegal acts are void, meaning they never existed in the eyes of the law. But it gets interesting with contracts that are legal in one state and illegal in another, especially now with things like online businesses operating across state lines. Capacity is also worth revisiting here. Minors, typically anyone under 18, can enter contracts, but they have the right to void them. This is called disaffirmance. A minor who buys a car can potentially return it and get their money back, even if the seller had no idea they were dealing with someone underage. There are exceptions, though. Contracts for necessities like food, shelter, and medical care are generally binding even for minors. Contracts against public policy are another category. Courts have struck down contracts that restrain trade too heavily, or that try to limit someone's right to sue for negligence. The law draws a line between private agreements and agreements that harm society broadly. All of this means you need to know not just what you are agreeing to, but whether what you are agreeing to is even something the legal system will protect. And once you have a valid contract, you need to know what happens when it breaks down. That is where we finish, with breach of contract and remedies. Section 5. Breach of contract and your remedies. So someone broke a contract, now what? This is where the rubber meets the road. A breach of contract happens when one party fails to fulfill their obligations under a valid agreement, either partially or completely. Not all breaches are equal. A minor breach might mean someone delivered goods a day late. A material breach is more serious. It goes to the heart of the deal and typically allows the non-breaching party to walk away and sue for damages. There are several remedies the law provides. Compensatory damages are the most common, money to put you back in the position you would have been in if the contract had been performed. Consequential damages cover losses that were a foreseeable result of the breach. Punitive damages are rare in contract cases, but can appear when fraud is involved. Sometimes money is not enough. Courts can also order specific performance, which means forcing the breaching party to actually do what they promised. This is most common in real estate cases, where the property is unique and money cannot truly replace it. Finally, there is the concept of mitigation. If someone breaks a contract with you, you are legally required to take reasonable steps to reduce your own losses. You cannot just sit back and let damages pile up, then hand the other side the bill. Contract law is not just about protecting big corporations. It is about making sure that when you make a deal, both sides are held accountable. So let's bring it all together. A valid contract needs an offer, acceptance, consideration, capacity, legality, and genuine assent. When any of those are missing or compromised, the contract can fall apart. And when someone breaks a valid contract, the law gives you real tools to fight back. Understanding this stuff does not make you a lawyer, but it does make you someone who cannot be taken advantage of as easily, and that is powerful. If this video helped you, hit that like button. It genuinely helps this channel reach more people who need this information. Subscribe so you do not miss the next video, where we are diving into specific types of contracts and what makes them unique. And drop a comment below with any contract questions you have. I read every single one. See you in the next one.